Pictures like that are pretty familiar to us. We see them all the time in films, television programs and the news. A crime is committed, the police make inquiries, they speak to witnesses, take statements and gather evidence, and then someone is arrested and driven away in a police car. But then what? What happens next? Cameras are not allowed inside courtrooms, and so what happens inside one is to most of us a complete mystery. But many of us may at some point have to attend court. We might be there as a witness or victim of crime, perhaps to serve on a jury. You may even find yourself in court on trial as the accused. A courtroom is a very formal and traditional place which can at first appear frightening and very complicated, filled with people wearing strange wigs and gowns and using words and language which most of us don't know or understand. Well, this programme will unravel some of the mysteries, explain the procedures and reveal what happens behind these doors as we follow the progress of a case through the Scottish criminal justice system.
A case typically goes through 4 main stages. Stage 1, the arrest and court appearance. Stage 2, preparing for court appearance. Stage 3, attending court, the trial. Stage 4, sentencing. After an offence is committed, statements are taken from the victim and witnesses. The police then investigate and gather evidence. Once a suspect is identified, an arrest is carried out and the suspect is taken to the police station and locked in a cell prior to interview.
Everyone accused of a criminal offence in Scotland has the right to a solicitor and may be entitled to free legal advice. The police can keep a suspect at the police station for up to 6 hours. The police must tell Darren that he has been kept or detained, and it's at this point that Darren may request a solicitor to be told that he is in the police station.
Darren can either use a firm of solicitors that he or his family knows or has dealt with before, or the police will contact one on his behalf from a list within the police station. Solicitors are completely independent from the police and the rest of the criminal justice system. A solicitor will be able to give Darren advice on the legal system and its procedures, and if necessary, represent him in court.
At the end of 6 hours, the police must tell Darren if he has been charged with an offence, and if not, he must be released. Darren has been charged with assault and robbery and will appear in court for the first time the next day. Once someone has been charged with an offence, the police continue to make inquiries about the crime and gather evidence. But the decision to prosecute a case is not made by the police. Their job is to detect crime and carry out initial investigations. The decision of whether to prosecute or not is made by the Procurator Fiscal Service.
The service has responsibility for the investigation and prosecution of crime on behalf of us, the people of Scotland. During a news report, you may have heard a reporter say, "A report has been sent to the Procurator Fiscal." What that means is a file which contains all the information about a case, including statements and evidence, is passed by the police to a Procurator Fiscal. The Procurator Fiscal, like Darren's solicitor, is a lawyer, but her job is to prosecute cases. Each case is unique and must be considered on its own facts and merits. The Fiscal will look very carefully at the case and consider if the right person is being prosecuted for the right offence.
There are a number of options available to the Procurator Fiscal. They may decide to issue a warning or a fine for minor cases. They may think that more evidence is needed and ask the police to carry out more investigations. Or they may decide not to proceed at all. In Darren's case, they have decided that there is enough evidence and will begin criminal proceedings against him.
Darren intends to plead not guilty to all charges, and so the defence team will also make their own investigations. This will probably include talking to police officers, the shop assistant, and others who were in the shop at the time of the robbery. Darren's defence team will also begin to interview witnesses who will give evidence for the defence. These are the people who may be able to back up Darren's side of the story. For example, by saying he couldn't have carried out the crime because he was with them. There are three main types of witnesses. Witnesses for the prosecution, those who saw the accused carry out the crime. Witnesses for the defence, those who do not agree with the version of events put forward by the prosecution. And expert witnesses. These are people who probably had no involvement with the crime, but have expert knowledge of a subject, for example, fingerprints or DNA.
In Scotland, criminal cases can be prosecuted either summarily or on solemn procedure.
Summary trials are conducted before a judge. The judge decides on all questions of fact and law, and they alone decide on guilt. There is no jury.
Summary trials are the most common form of trial in Scotland and are a quick and efficient means of administering justice.
Solemn trials involve a jury of 15 people, randomly selected from the community, and are conducted for more serious crimes such as robbery or murder.
Darren's trial will be conducted on solemn procedure with a jury and will take place in the Sheriff Court.
Many people are involved in a solemn trial. A sheriff will be appointed to preside over the case. A procurator fiscal will lead the case for the prosecution. A defence solicitor will represent the accused. Witnesses are required, and members of the public who may become members of the jury.
With only a few exceptions, everyone in Scotland aged between 18 to 65 may be asked to sit in a jury.
Jury service is an interesting and important public duty. It gives ordinary members of the public the opportunity to make a vital contribution to the administration of justice in Scotland. The Scottish court system provides courts at 3 levels to administer criminal justice. The district court deals with the most minor cases, such as traffic offences or shoplifting. All cases at the district court are conducted on summary procedure. No jury trials are possible at the district court. Most large towns in Scotland will have a district court which are run by local councils. The Sheriff Court deals with more serious crimes such as drug offences and housebreaking. The Sheriff Court can hear criminal cases either with or without a jury. The judge who presides over cases is known as a sheriff. We'll tell you a little more about the sheriff and their duties a little later on. The most serious of criminal cases, such as murders, are held in the High Court. All trials in the High Court are heard with a jury.
This programme has looked at the first 2 stages of the criminal justice system in Scotland, the arrest and preparing for trial. In the next programme, we'll take a look at what actually happens inside the court as Darren's trial begins. Many of the people who pass through these doors today will probably never have been in a courtroom before. Witnesses, potential jurors, victims, people accused of an offence will all probably feel a little bit anxious about what lies ahead. But for some, attending court is an everyday occurrence. In fact, it's their job.
Everybody here is very familiar with the courtroom and the procedures. The prosecution team and the defence are able to chat and joke with each other whilst they prepare for the trial ahead. And the officials of the court make sure that everything is in place to allow the trial to begin on time. Physical evidence, such as the clothing and the videotape from the CCTV, is known as label production. Written evidence, such as statements or fingerprint evidence, is called a documentary production. The clerk of the court checks that the equipment inside the courtroom is working properly. The televisions may be needed to watch the video from the CCTV.
In sensitive cases where younger children are required to give evidence, the child often sits in another room and their evidence is relayed into the courtroom via the TV screens. This can spare the child the ordeal of being in a courtroom full of strangers.
The whole trial has to be tape recorded. This allows evidence to be re-listened to if there is a dispute about exactly what a witness has said.
Whilst everyone here is getting ready, the sheriff is preparing away from the courtroom in an area known as chambers.
The title of sheriff is a very ancient one, dating back almost 1,000 years. It comes from the words shire, meaning area, and reeve, which means the king's representative.
Back then, sheriffs carried out the wishes of the king, acting as judge, local administrator, military officer, and tax collector.
As well as presiding over criminal trials, sheriffs today are also required to carry out a lot of other kinds of legal work, including authorising search warrants for police officers, finalising adoption, divorces, and overseeing fatal accident inquiries.
Sheriffs have a very important role in the criminal justice system. They need to be experts on the law and to ensure that each case is judged in a fair and balanced way.
Although sheriffs will have spent many years as solicitors or advocates and will have a wide knowledge and expertise about the law, a library of journals and books are provided to help them interpret the law in an impartial way. Court normally begins at 10 o'clock. In some courts, people who enter have to go through certain security procedures, similar to those you may have experienced at airports, to make sure they are not carrying a weapon or concealing a camera, as you are not allowed to take pictures in a court. Each of the different participants in Darren's trial will be told where to wait. All witnesses, like the police officers and the shop assistant, will be shown to the witness room. Witnesses for the prosecution wait in separate rooms from defence witnesses. Potential jurors will be asked to wait in the courtroom where the trial is to take place. Also in the court may be the accused waiting for the trial to begin, families of those involved in the trial, members of the press, and members of the public.
Anyone over the age of 14 is allowed to come to court and watch proceedings, but school children under 14 years may be allowed in for educational purposes if the sheriff allows it and providing they follow a few rules. You must be dressed appropriately. Football tops or t-shirts which may cause offence are definitely not allowed. Hats or caps must also be removed. You mustn't eat, drink or chew gum in the courtroom. When the court is in session, That means when the judge or sheriff enters the courtroom, you mustn't talk or read.
Good morning, ladies and gentlemen. Thank you for your appearance today. Before I explain the practice and procedures of today's hearing, I'd just like to check who's here, so bear with me. Alex Purvis.
In order to be excused from jury service, a potential juror must have an important reason, such as a hospital appointment, or caring for young children, or an elderly relative. Excuses, such as being busy at work, will probably not be accepted.
Thank you, ladies and gentlemen. What you just observed is me putting the names in the bowl, and what will happen thereafter in a few moments when the sheriff comes on the bench is I will call the names out. It's a random choice. So if your name is called, please come forward and take a seat in the jury box, which is situated over there. If at any time you recognise someone in the proceedings, please let us know. It's an important step. If you recognise the accused or a witness, please let me know immediately. It may have a bearing on the case and your ability to sit on it. If there is anything else that you have to ask or any inquiries you need to make, then please let me know now. Thank you again for your attendance today.
The sheriff has to be in the court when a jury is selected. So when everyone is in place, the court officer is sent to the chambers to accompany the sheriff into court.
Come in.
Morning, Sheriff.
Morning, John.
How are you this morning?
I'm very well. Do you have a good weekend?
Not bad at all.
You ready for me?
Yeah.
The people waiting in the courtroom and the sheriff are currently fairly relaxed and able to chat informally. This will all change as soon as the sheriff enters the courtroom.
There you are. Can you take these for me, thank you?
Good right.
As acknowledgement of the important position that the sheriff represents, everyone must stand when the sheriff enters or leaves the courtroom. As a mutual mark of respect, the sheriff bows to the court and the court officials bow in return. The clerk of the court will now officially call the case and Darren will tender a plea.
Call the diet, Her Majesty's Advocate against Darren Ballantyne. Can you come forward, please, Mr. Ballantyne?
An accused person may decide to change their plea from not guilty to guilty, even at this late stage. If they do, no jury or trial will be needed.
Have you done Ballantyne? Yes, have a seat.
The process would proceed to the sentencing stage.
Yes, Milady, I appear for Darren Ballantyne, who pleads not guilty to the charge on the indictment.
Milady, I'd be obliged if the court can proceed to trial.
Ballot, milady. Okay, ladies and gentlemen, when I call your name, if I can ask you just to come forward and take a seat in the jury box. Number 12 on the list, David Wilson. Number 2, Christine Knox.
In Scotland, 15 people are required to serve on a jury. Some people are exempt or disqualified from jury duty, including those involved in the administration of justice, such as police officers or lawyers, and those who have been convicted of a serious criminal offence.
Suzanne Senior. Number 27, Duncan Robertson.
Once all 15 members of the jury have been chosen or impanelled, the clerk of the court will read out the indictment or charges against Darren, and the sheriff will address the jury.
Ladies and gentlemen, I'll now read the indictment to you, and after that I'll ask you to stand and raise your right hand, and at that stage I'll administer the oath to you, and I'll simply look for you to say "I do" once I've done that. So the charge against the accused is Darren Ballantyne of 4 Main Street, Edinburgh, indicted at the instance of Colin Boyd, Lord Advocate. The charge against him is that he did, on 13th June, in the premises at the High Street, Edinburgh, occupied by Superstore Groceries, you did assault Mary Jenkins, shop assistant, by slapping her on the face and rob her of £250. Can I ask you to stand, please, and raise your right hand? Do you swear by Almighty God that you will well and truly try the accused and give a true verdict according to the evidence? I do. Have a seat, please.
Mr Gilmer, would you hand copies of the indictment out to the members of the jury, please?
Each member of the jury will now receive a copy of the indictment. Throughout the trial, the jurors may receive further copies of important documents, such as witness statements or pieces of evidence. The sheriff will also receive a copy. The copies are often on colour paper to distinguish the copies from the original.
Now, ladies and gentlemen, you may not be familiar with the practices in this court, and it may be of some assistance if I outline the procedure that will be followed. Now, the case for the Crown is presented by the Procurator Fiscal, and that's the lady sitting on my right facing you. The case for the defence is presented by Mr Scott, who's the gentleman at the desk on my left, sitting with his back to you.
In Scotland, there are no opening speeches. The trial officially begins when the first witness for the prosecution takes their place in the witness box and takes the oath. As the Procurator Fiscal or Crown has brought the case to court, the whole of the prosecution case is heard first.
Procurator Fiscal, would you like to call your first witness, please?
I'm obliged, my lady. I propose to call witness number 1 for the Crown, Mary Jenkins.
Is it Miss Jenkins or Mrs Jenkins?
Mrs. Jenkins.
Will you take the oath, please? Just raise your right hand and repeat after me. I swear by Almighty God.
I swear by Almighty God.
That I will tell the truth.
That I will tell the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Miss Dalrymple?
As this first witness is a witness for the prosecution, the Crown will ask questions first. The defence solicitor may then ask the witness some questions. This is called cross-examination. When the cross-examination has finished, the Crown may ask a few more questions to clear up some issues. The procedure is the same for defence witnesses, except the defence asks the questions first.
Now that everyone is in place, let's take a closer look at the people inside the courtroom, who they are and what their role is.
The witness box is where each of the witnesses will stand to give their evidence. It directly faces the jury to allow them to see the witness clearly. Although a chair is provided, most witnesses are required to give their evidence standing up, to allow the jury to see the whole of the witness's body. The Procurator Fiscal will prosecute the case or present the case for the Crown. The accused is considered to be innocent until proven guilty. The prosecution has the burden of proof, which means that they need to present enough strong evidence to convince the jury that the accused is guilty of the crime. The defence solicitor sits on the right. It's the job of the defence team to test the prosecution case. The defence does not need to prove anything. Remember, it is the prosecution who has to prove guilt. The defence does not need to prove innocence. The defence may choose to present evidence to the court to support the defence case, but they don't need to. The clerk of the court is responsible for writing up procedural steps in each case and advising the sheriff on procedure. Other duties include tape recording the proceedings, safeguarding the tapes, and ensuring whenever possible that the court runs smoothly. The court officer is responsible for bringing people in and out of the courtroom. He brings pieces of evidence to witnesses and generally helps the courtroom run smoothly. The sheriff is the master of the law. It is the sheriff's function to regulate the procedure of the case and to explain the law to the jury. You will notice that all these people are dressed in black gowns and that the sheriff is wearing a wig. This is a tradition that dates back many hundreds of years. Back then, the only people who could read and write were priests and ministers of the church, and so it was they who carried out much of the work of judges and legal advisors. It was only natural that they wore the same clothes in court as they did in church. To begin with, they carried out their legal work free of charge. But gradually, they began to demand payment. Many neglected their churches and concentrated instead on earning extra money through their legal work. The bishops decided to put an end to this and ordered the ministers not to ask for payment. To get round this, some ministers had their gowns made with small pockets at the end of the sleeves, into which clients would slip some money. The ministers could then honestly say to their bishop that they did not ask for any money, nor did they see anyone give them money. Angered by this, the bishops demanded that they stopped carrying out any legal work at all. But many were making a lot of money and didn't want to stop. But by wearing a wig, they were able to disguise the fact that they were ministers and were able to carry on. The tradition of gown and wig wearing continues in many countries to this day. The purpose of the jury is to judge the facts of the case. It is said that the jury is the master of the facts. They must decide if they find witnesses reliable and believable, and whether they think the Crown has provided enough evidence to prove that the crime was committed by the accused beyond reasonable doubt. It is extremely important that each member of the jury pays careful attention to all the evidence. Their verdict must be based on the evidence presented in court and nothing else. They are provided with pens and paper to allow them to take notes. Jurors must not talk about the case to anyone except their fellow jurors, and only then in the privacy of the jury room.
No juror should have any contact with an accused person, and it is a serious offence for anyone to try to obtain information from a juror about any of the matters discussed by the jury, even long after the trial has ended. Trials can often last many days, perhaps weeks, and in very complex cases, even months. Jurors are paid travelling expenses and an allowance for any money they might lose whilst not at work.
Members of the public, family, and those interested in the case sit here in the gallery. Some courtrooms have special areas for the press to sit. The accused sits here in the dock. The dock is directly connected to the cells underneath. For security reasons, police officers sit either side of Darren. No one is allowed to touch him or give him anything unless they've had permission from the sheriff.
In the next programme, we will look more closely at the role of the witness and the juror and watch as the trial reaches its conclusion. While the trial continues in the courtroom, witnesses must wait here in the witness room. Witnesses may have to wait a long time before they are called to give their evidence, and while the court is in session, they must remain in the witness room. Like jurors, witnesses can claim travelling expenses and an allowance for any loss of earnings.
It's important that witnesses do not discuss the case with each other, as they may be asked about this in court. This may lead the jury to doubt the evidence that they give. Until they have given their evidence, witnesses are not allowed to see or hear any of the trial, as this may influence the evidence that they give to the court.
No further questions for this witness, my lady.
That's all, Mrs. Jenkins. You're free to leave the court or take a seat at the back as you wish. Thank you.
Once the prosecution and defence teams have no more questions for a witness and they have finished giving evidence, they may join the members of the public in the gallery to watch the rest of the trial. Witnesses, such as the young boy, may want to bring someone to court to sit with them, but his mum will not be allowed to go into the witness box with him. Children often find the experience of giving evidence very difficult and traumatic. The court does its best to make children feel as comfortable as possible.
Yes, Miss Dalrymple, your next witness.
My lady, my next witness is number 3 on the indictment, Aaron Matthews. My lady, this witness is 11 years old. I have discussed the court arrangements with the witness and his mother, who he has brought along as a support person, and he has decided to sit at the table. And I would be obliged if the court officials could remove their gowns and wigs, my lady.
Yes, very well. We'll do that, and we'll bring him in, and he can sit at the end of the table here.
I'm obliged, my lady.
Very well.
In some cases, the sheriff may ask all members of the public to leave the court.
Now, Aaron, have you been here all day waiting to get in this court, have you?
Yes.
And what age are you?
I'm 11.
You're 11. When was your birthday?
The 27th of August.
Of August. And so, Aaron, have you got the day off school today?
Yes.
Yes. And do you have to go back after you've given evidence, or are you off for the whole of the day?
I think I'm off for the whole day.
I see. And what is it you want for Christmas?
A mountain bike.
A mountain bike? Do you not want your mum to take you to see the new Harry Potter movie? Have you not seen it?
No.
But you know it's full of magic, don't you?
Yes.
And you know the difference, do you, between magic and what's real?
Yeah.
And you know the difference, do you, between telling lies and telling the truth?
Yes.
Right. Well, can I tell you that in this court you have to tell the truth? You understand that? Mm-hmm. Now, your mum's sitting in the back row there behind the dock, and she's here to support you, all right? And what does she do to you if you don't tell her the truth?
I get grounded.
So do you tell her lies often or not very often?
Not very often.
Not very often, because you don't want to be grounded too often, do you? Mm-hmm. Right. Now, this lady here is going to be asking you questions about what happened on a day in June last year, all right? It's very important that you answer her truthfully. You understand me? When she's asked you some questions, Mr. Scott, this is the man sitting facing you, he might have some questions to ask you as well, and you must answer him just as truthfully, all right?
Yes.
Now, if you want a break, will you let us know and we'll arrange to have a break for you? And if you want a drink of water, just let me know. All right? Okay. Yes,
I'm
Mr.
obliged, my
Hamilton.
lady. So, understand that your full name is Aaron Matthews?
Yes.
Right, okay.
As with all prosecution witnesses, Aaron will first be asked questions by the Crown and then cross-examined by the defence solicitor.
And the sheriff would like
Was there anyone else in the queue?
Yes.
Right. Do you know how many other people there were in the queue?
I'm not sure.
Right. Okay. And did something happen?
Expert witnesses and police officers are treated the same as the other witnesses. They too are asked detailed questions. However, because a police officer may deal with a number of incidents every day, it may be difficult to remember exact details about a particular case, so they can ask to refer to their notebooks.
Could I refer to my notebook?
Did you take the note at the time?
I did.
Yes, very well.
I suggest to you, officer, that your evidence is nothing but a tissue of lies. Is that not the case?
That's not the case.
And you would have said anything today to get my client convicted, wouldn't
That's
you?
not true.
And no further questions, my lady.
Miss Dalrymple.
I have no further witnesses for the Crown, my lady, and I formally close the Crown case.
Ladies and gentlemen, the Procurator Fiscal has closed the Crown case. That means that you've heard all the evidence that she proposes to lead before you in relation to this charge. Mr. Scott, what's your position?
At this stage, my lady, I would indicate that I have a submission of no case to answer, which would clearly require to be heard out with the presence of the jury.
Often at this stage in the proceedings, the defence solicitor makes a submission to the court that there is no case to answer.
If this happens, the jury are asked to return to the jury room so that the sheriff can hear the legal arguments from the defence and prosecution.
Yes, Mr. Scott.
Right. Yes, my lady. The situation here is that, so far as sufficiency is concerned, I have some problems. I think there may be a technical sufficiency, but I don't think that the evidence marries up in a way that would entitle the Crown to get beyond this stage.
Basically, the defence is trying to convince the sheriff that the Crown has not brought enough evidence to prove that the crime was committed by their client. If the sheriff agrees with the defence argument, then the trial will be stopped and the accused acquitted.
If the sheriff disagrees with the submission, the jury is brought back into the courtroom and the trial continues. And the defence can begin to call defence witnesses.
But remember, the defence does not have to call witnesses to prove that the accused is innocent. The prosecution must prove beyond reasonable doubt that the accused is guilty.
I have no hesitation in repelling it.
Once all the evidence has been given, the fiscal and the defence solicitor start their closing speeches, talking directly to the jury.
Miss Dalrymple, can I ask you to address the jury on behalf of the Crown, please?
This is the last chance to remind the jury of the evidence that has been presented.
Ladies and gentlemen, it now falls upon me, as the Procurator Fiscal Depute, to address you about the case and the evidence that we've heard and seen over the past few days. Finally, ladies and gentlemen, I would ask you to consider all the evidence in this case very carefully and the points that I've made in relation to it. I would invite you, ladies and gentlemen, to convict the accused of the charge on the indictment. Thank you very much for listening.
Mr. Scott, can I invite you now to address the jury on behalf of the defence?
It also gives the defence team an opportunity to challenge that evidence and to question the reliability of Crown witnesses.
In this case, as in every other criminal case in our courts, the starting point for you is that my client, the accused, is presumed to be innocent of this charge. And that doesn't change unless the Procurator Fiscal satisfies you beyond a reasonable doubt is that his evidence was wholly unsatisfactory and not good enough to assist the Crown in seeking to convict my client. In all the circumstances, I would invite you, ladies and gentlemen, to accept that there is a reasonable doubt left in this case, and in those circumstances to acquit my client. Thank you for your attention.
After the closing speeches, the sheriff will address the jury. This is called charging the jury. During this speech, the sheriff tells them of the laws that apply to the case and reminds them of their duties as jurors.
Ladies and gentlemen, you've now heard all the evidence, the speeches for the Crown and for the defence. At this stage, I have to explain the legal rules that are relevant for deciding this case, and you must accept these instructions in law from me and apply them to the facts in reaching your verdict. There are 3 verdicts open to you: guilty, and not proven. Not guilty and not proven are entirely the same. They're both verdicts of acquittal. In each case, the accused would walk free, never to be tried again. In effect, they are identical verdicts. If you propose to return a verdict of guilty, can I say that at least 8 of your number must be in favour of that verdict? You decide which witnesses you believe and which you disbelieve. You decide which witnesses you find reliable and which are not. You can look at the content of the witness's evidence, and you can also take into account their demeanour or their body language when they're giving their evidence. Doing that and comparing what what each witness says with other evidence in the case can help you to assess the credibility and the reliability of each witness. You can also test their evidence by plain common sense. Ask yourself, does their evidence ring true? Reach your verdict, ladies and gentlemen, on the basis of the evidence and the reasonable inferences or deductions or conclusions that you can draw from these pieces of evidence. Don't speculate, don't guess. And ladies and gentlemen, don't be swayed by emotional considerations or any prejudice. Put sympathy aside. Your function now is a judicial one, and you have to approach the evidence impartially. Ladies and gentlemen, can I ask you to retire now? Please don't rush to your verdict. Take your time in your deliberations. It's clearly an important matter for the Crown, who represents the public interest, and it's an important matter for the accused. I'll ask you to retire now, and if you let us know when you've reached a verdict. Thank you.
The jury now returns to the jury room to consider their verdict.
One of the first things that the jury must do is to choose someone to be foreman or forewoman.
Okay, well, we're going to have to appoint a spokesperson. Does anyone really particularly want to do this, or no? What about you?
Well, if nobody else wants to do it.
This juror will be in charge of the discussions inside the jury room and will speak for the jury when they return to the courtroom. There are no fixed rules or procedures about how the jury discuss the case or reach their verdict. Each jury will conduct itself in a slightly different way. The jury can take as long as it needs to discuss the case and to reach a verdict. In some cases, it may even be necessary for the jurors to stay in a hotel overnight rather than return home. To help them during their discussions in the jury room, the jury can refer to any notes that they have taken or request to see copies of productions. Whilst in the jury room, jurors are not allowed to leave or to contact anyone, and no one except a court official is allowed to enter. At mealtimes, the court will provide refreshments. For a verdict to be given, a majority of the jury must agree. A majority is always 8, even if due to illness a juror has left the trial. Whilst the jury deliberates, others involved in the trial await its verdict. As we said earlier, when considering a verdict, the jury are not allowed to leave the room, so they communicate with officials of the court by pushing a buzzer or a bell or by knocking on the door. Everyone now assembles to hear the verdict of the jury.
Ladies and gentlemen, have you elected a spokesperson? And if so, will that person please stand? Have you reached a verdict?
Yes.
What is your verdict in respect of the accused?
Guilty.
Guilty. Is that by majority or unanimous?
By majority.
If you have a seat just now, please, and I'll record the verdict. Ladies and gentlemen, is your verdict properly recorded as follows? The jury, by majority, find accused guilty as libelled. Thank you.
Having delivered their verdict, the work of the jury is done, and the case now moves on to stage 4, sentencing. The fiscal and defence lawyer make recommendations to the sheriff on what the sentence should be.
Ms Dalrymple?
Lady, in light of the jury's verdict, I formally move the court for sentence. There is nothing libelled in respect of this matter.
No previous convictions?
No, my lady.
Thank you.
The fiscal will tell the sheriff of any previous convictions, if there are any, and the defence solicitor will give some background information about Darren.
Thank you. Mr Scott?
The jury has convicted my client of clearly a very serious charge, but he is only 19 years of age.
When deciding what sentence to impose, the sheriff has to take into account both the facts of the offence and the circumstances of the offender. The sheriff has a number of sentencing options that she can impose, some of which include a fine, community service, or imprisonment.
I invite your ladyship to allow him to remain on bail in the meantime, with all options being kept open.
Yes, thank you. Stand up, Mr. Ballantyne. This was a very serious matter, Mr. Ballantyne, but as you are a first offender, I will require to call for a social inquiry report and a community service report.
The sheriff cannot impose a jail sentence on a person who has never been in jail before without requesting background reports. These reports help the sheriff decide what would be the best and most appropriate sentence for the public and for the offender.
Darren may be given bail, which means he is free to leave but must return to the court to be sentenced. Or he may be held in custody, which means he will be kept in prison until the date of the sentencing hearing.
Sentence will require to be adjourned, therefore, for a period of 3 weeks in order that these reports can be obtained. Bail's continued.
Mr Ballantyne, that is adjourned your case till the 18th of December for the purpose of obtaining social inquiry and community service reports. Bail will be continued as previously granted. That's all, thank you.
Ladies and gentlemen, can I thank you for the obvious care and attention that you've given this case throughout. Your availability to serve as jurors is an essential part of the system of justice in Scotland. I hope you've not been unduly inconvenienced, and I do hope that you found the experience of some interest. Can I now discharge you from your duties as jurors with my thanks? Thank you. Mr. Scott.
Yes, my lady. I appear again for Darren Ballantyne. There is a report now available. The factors I would simply wish to emphasise are that he is only 19, he's in full-time employment, he comes from an extremely supportive family, and they've attended again today as they did during the course of the trial. He had never been in trouble at all before, apart from this matter, and the terms of the social inquiry report are extremely favourable. Community service is available as a direct alternative to custody, and on the strict understanding that it is as an alternative to custody, I would invite your ladyship to place him on a period of community service.
Stand up, Darren Ballantyne. As you now know, assault and robbery is a serious crime, and your appalling behaviour on the 13th of June clearly has had a very distressing and frightening effect on the victim, Mrs. Jenkins, and also on the child. Normally you could expect to be sentenced to a lengthy period of detention for a crime such as this. However, I've read the terms of the social inquiry report, I've taken account of your previous good record, and I've taken account too of your genuine remorse, as well as the other factors referred to by Mr. Scott in mitigation. I am therefore prepared on this occasion to impose a non-custodial sentence. I propose to make a community service order requiring you to perform 300 hours of community service. This means that you're required to carry out 300 hours of unpaid work in the community. This work will be carried out under the supervision of the local authority, and you must carry this work out at such times as your supervising officer instructs. You must report to that officer when required to do so, inform him of her of any change in your address or times of employment. You'll have 12 months from today's date within which to carry out the 300 hours of community service. If you fail to comply with this order, you may be brought back to court. The community service order will then be revoked, and you may be dealt with as if no such order had been made. Accordingly, it will be open to the court to imprison you, and you should bear in mind that community service is an alternative to a prison sentence. Now, do you understand what's been said to you?
Yes.
And do you agree to comply with all these conditions?
Yes.
Very well. 300 hours community service.
Darren Ballantyne, 300 hours community service orders imposed. A copy of the order will be sent to you, and a social worker will be in touch with you in due course. That's all, thank you.
Throughout these programmes, we have tried to explain the procedures and traditions of the court, and hopefully you now have a better understanding of how a court operates, who's involved, and the roles we all play in the Scottish criminal justice system. Without members of the public coming forward as witnesses or to serve on a jury, it would not be possible for the Scottish legal system to maintain the high standards which have been achieved for hundreds of years.